Breaking news on civil rights in the Trump Justice Department. Donald Trump's pending nominee to be the #2 Deputy Attorney General at DOJ, who would replace Rod Rosenstein, was at a confirmation hearing today and refused to answer whether or not he agrees with the landmark Supreme Court rulings of Roe v. Wade, which of course establishes the right to choice, and one of the greatest canonical rulings of all time, Brown v. Board, which formally ended racist segregation in American schools.
Was Brown versus Board of Education correctly decided?
Senator, I don't think that it would be a productive exercise for me to go through the most thousands of Supreme Court opinions and say which ones are right and which ones are wrong.
These are pretty simple questions. They're answerable by yes or no. Most lawyers, I suspect, would agree, based on knowledge of the law, that these two cases, pillars of our jurisprudence, were correctly decided by the United States Supreme Court.
I have views about lots of Supreme Court cases, but I'm not being nominated for this position to be the Solicitor General, nor a judge. And I think in this context, the point I'm trying to make is that whatever the law is, whether it's the decision I would favor or disfavor, I see it as the role of the Department of Justice to uphold the law such as it is, unless Congress or the courts change it.
You are in charge of the arguments that are made to the Supreme Court. You would be in a position to suggest that the Solicitor General argue that Roe v. Wade should be overruled. That's why I'm asking you this question. Same with Brown versus Board of Education. And we're entitled to know your personal views.
An important moment at that hearing. I am joined by phone by Vanita Gupta, who ran the Justice Department's Civil Rights Division under the Obama administration. I'm also joined by former federal prosecutor Glenn Kirshner, who can speak to some of these issues. Vanita, your view of what we just heard.
It's totally unacceptable. Brown versus Board of Education is one of the most consequential cases in our nation's history. It ended legal apartheid and racism in the law in this country. It's settled law. It has been since 1954. And there's simply no reason why any nominee to any position in our government should be unwilling to say that. In my mind, if you can't agree that Brown versus Board of Education was correctly decided, you don't belong in the Justice Department, either as a line attorney or as a deputy attorney general. One of the primary roles of the Justice Department is to protect civil rights. And if any nominee is unwilling to accept bedrock settled civil rights laws, then they just shouldn't have the job.
And when you look at the argument made that basically this nominee doesn't want to be drawn out under oath on every case out there, what is your response to that? What makes this case so obviously different, I guess?
I mean, as you said, this is a canonical case in our nation's history. And the question is, does Rosen really believe that the legality of de jure racial discrimination is going to come up during his tenure as a deputy attorney general? To me, this begs the question of, what does it mean for the Justice Department's really crucial role in enforcing civil rights that he isn't willing to commit unequivocally to the fact that this canonical case that ended legal apartheid in our country was correctly decided. You even had justices, nominees. Justice Gorsuch had said that Brown versus Board of Education was a seminal decision that got the original understanding of the 14th Amendment right. I mean, even Brett Kavanaugh, for Pete's sake, said that it was one of the most important, the single greatest moment in Supreme Court history. And so this is a guy who is running, who has been nominated to be the #2 in the Justice Department, overseeing civil rights enforcement and much more. And I just think it's unacceptable.
Glenn, I wonder your view of this, and if you have a question for Vanita, who obviously has been so central on really the intersection here, how a Deputy Attorney General and the Attorney General deal with civil rights and the Civil Rights Division at DOJ.
You know, Ari, we're used to judicial nominees dodging questions about cases that may come before them in the future. But this is going to be potentially, if confirmed, one of the top law enforcement officers in the country, the Deputy Attorney General. And for him to even sort of leave a little bit of daylight for the notion that Plessy versus Ferguson, the Supreme Court case that said separate but equal, government-sanctioned racial segregation is okay. Maybe it's still in play because Brown versus Board of Education, which we all thought put a nail in the coffin of Plessy versus Ferguson's horrific separate but equal doctrine. What kind of a signal does that send to have somebody like this be involved in weighty decisions concerning the sort of the fairness and the equality with which our laws are carried out? But I appreciate you letting me ask Vanita a question. So, Vanita, when you were heading up the civil rights practice in the Department of Justice, if you saw somebody come in like this, the number 2 person in the Department of Justice with this mindset, how do you think that would have impacted the morale of the many, many attorneys that you supervised who were working our country's civil rights cases?
Look, the morale in the Civil Rights Division, unfortunately, is really low at the moment. Jeff Sessions didn't do much to help morale and had done so much to already gut civil rights enforcement in the division. But this kind of thing it's bigger. It is really signaling to the country the degree to which these kinds of reactions and non-statements are becoming acceptable in our government officials. And, you know, we had Charlottesville, and all of us had to reckon with seeing a president refuse to unequivocally denounce white supremacists, many of whom had been marching in his name. But to now have increasingly, you know, judicial nominee after judicial nominee, and now in the executive branch to have somebody who is tasked with overseeing the enforcement of civil rights laws try to be smart and coy with one of maybe the most foundational decision to our democracy, you know, it is deeply, it's just unacceptable, and it's deeply demoralizing. And I'm sure that the lawyers in the Civil Rights Division, you know, are asking themselves, what does the justice part of the Justice Department mean to have a nominee actually, you know, give that kind of testimony today. And remember, he also refused to say whether birthright citizenship is guaranteed by the 14th Amendment. You know, there were a few other kind of tidbits from today's testimony that should shock the conscience. Right,
and this is where the rubber hits the road. I mean, we heard in the hearing the senator saying, look, this is the person who's going to oversee the decisions are made about what is defended at the Supreme Court. The president can tweet, the president speaks in all sorts of ways, but line by line, case by case, the human rights of American citizens, a lot of this is taken out at the level of what's really going on in the Trump administration, which is why we wanted to cover that moment. The vote's obviously still pending, and Vanita Gupta, so experienced on this. Thanks for hopping on the phone with us on this.
Thank you for talking about it. Thank you.
Thank you. Glenn stays with me because I have breaking news in our hour, as it sometimes happens. Glenn, I want you to speak to me about something right up your alley as a legal issue. I'm holding a brand new letter from the Trump Department of Treasury that just hit the wires. They are trying to buy time, punting on the request for Donald Trump's tax returns, an issue that obviously has dogged Donald Trump's candidacy from the moment he announced the president. Reading from the letter here to Chairman Neal, who under the federal law can personally request the returns without a wider vote. Secretary Mnuchin says, I write in response to your April 3rd letter, the committee requests these materials by April 10th. The Treasury Department, quote, will not be able to complete its review of your request by that date. And it goes on, Glenn, to outline why this is a allegedly extraordinary request, buy for time, and potentially, I suppose, set up what might be a big legal clash. Your view of this next step in this fight?
You know, is there any evidence that they're not willing to suppress, Ari? The statute couldn't be clearer. It says that if the chairman of the House Ways and Means Committee, in writing, makes a request for the tax return of any person, that would include the president, it must be given over. This seems to be nothing more than another delay tactic. You know, all the people are looking for, all the Congress is looking for, is information, truthful information, accurate information. What's in the president's tax returns? What's in the Mueller report? What are the facts that will guide our decisions? You know, we have Attorney General Barr saying, don't worry about the facts, trust me. Let me go ahead and jump out and exonerate the president on as many fronts as I can without sharing any of the evidence with the American people or with the Congress. And here we go again
Right.
with the same thing happening now on the tax front.
And interestingly, this letter, which is just breaking, it's not a hard no either. It's a sort of a step in what they may know is better off buying for time if they're worried about their legal posture or they want more time to guard it. Glenn Kirshner on multiple stories tonight on The Beat. Thank you for joining me. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.